now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please have a seat. You will stand. And for the record, say and spell your first and last name, please.
Ian, I-A-N, Malatesta, M-A-L-A-T-E-S-T-A.
Thank you, Honor. Mr. Malatesta, what is your occupation?
I'm an attorney, licensed to practice law in California since 1977.
And do you have a specialty?
Family law.
Can you give us a little background of your experience in this area of the law?
Well, after law school, I practiced with two prominent law firms, Grayson, Gross, Friedman, and Phillips in Westwood, and then Eisfelder and Eliezer in also in Westwood. And I've been on my own as a sole practitioner since 1989.
Are you currently practicing or retired or in between?
Actually, I'm in between. I'm a mediator.
And when did you retire from your active practice?
May of 2023.
And do you have any specific experience or background in the area of family law, community property, specifically divorce cases?
Well, I've handled over 1,000 divorce cases myself. I've represented different people, actors on Melrose Place and Cheers. I represented myself, the executive producer of Law and Order, the executive producer of Everybody Loves Raymond. I represented...
Did you represent any normal people?
Well, 98% were working people. That's how I built my practice.
And how many of these cases through the years involved divorce?
All divorce or just prenuptials or paternity. But all family law related issues. Spousal support, child support, paternity, you name it in family law, I've tried it.
Mr. Malatesta, did I retain you to be an expert in this case if needed in the area of family law, divorce, and community property?
You did. I was retained in February of 2025.
And are you being paid for your testimony and research and investigation today?
I am.
What is your fee? I mean, what have we paid you?
I was paid a retainer of $7,500, and I'm billing at my rate, which has been the same rate for 20 years, which is $550 an hour.
How much time would you estimate that you've put in so far in investigating the facts of this case as it relates to divorce and community property?
I estimate that the retainer will cover, I was here on February 10th to hear the testimony of Ms. Ebersbacher. I was here to hear all of that, and today, and I prepared a report regarding her testimony, and I estimate that the retainer will cover all of that. I've been on call for a while, and I'm not going to worry about that. When you and the court need me, I'll be available, and I'm here today to testify.
You understand it's hard to predict how long a witness may take.
Yeah.
Okay. Hopefully yours will not be 3.5 days.
Yeah.
Okay. Did well, if you were here for the testimony of Ms. Ebersbacher, did you observe what was marked as Exhibit 126, which is labeled Death versus Divorce at the top under Sementilli. Do you see that?
Yes, I have that. I reviewed that.
Okay, and it's right on the screen to your right, I believe, if that's the same report, is it?
Yes.
All right. And did you hear Ms. Ebersbacher testify regarding the issue of alimony as it might apply to the question of divorce versus death in this case?
I did hear her testimony.
All right. And on this chart, which has been displayed, did you see a section that dealt with the issue of alimony.
No, I did not.
And you understand that this chart is supposed to have indicated or documented certain amounts that Ms. Sementilli would receive upon the death of her husband versus the divorce of her husband. You see that?
Yes, that was what she was, I think, trying to do.
Okay.
But spousal support was left out, which is the major issue in a 20-some-year marriage, which I was told the Sementillis had.
So I was going to ask you then, you heard her then opine on the issue of alimony, but indicated it was not on the chart, correct?
Correct, I heard that.
All right, and in your opinion, would that be a major factor in determining whether or not financially it was more beneficial for Monica Sementilli's husband to be deceased or to be the subject of a divorce?
Yeah, in my opinion, it would have been the main issue. It would have been $1 million issue if I was representing the family, either one of them.
Can you explain then, based on the hypothetical of the deceased having been involved with the defendant in a 20-year marriage with a salary between $200,000 and $300,000, can you opine on what the potential alimony would have been had there been a divorce proceeding?
Sure. I mean, that's as a family law attorney, I've handled spousal support, basically every case. But I believe Ms. Ebersbacher said that Mr. Sementilli was making approximately $280,000, which was the number I used, and that Mrs. was earning somewhere between $10,000 and $20,000. So in family law, that would have been the single most important issue to deal with.
Why?
Because it's a long-term marriage under Family Code 4320, and a woman in her position would have been entitled to basically 1/3 of his income based on the length of the marriage and the other factors, lifestyle, do they have minor children, separate property, any other factors. So it's like 10 factors. And I value that as $1 million issue. I basically, in my mind, if I was representing either one of them, you represent a husband, you try to buy out spousal support or...
What does that mean?
Well, buy out. Some people in marriages are worth, marriages of duration of, like, let's say they were married, use this, 8 years. And she would be entitled to basically 4 years of marriage and 8, because lengthy marriage under the code is defined as any marriage over 10 years. This is way above that. This is 20-some years.
All right.
So in an 8-year marriage,
okay.
Let me finish. In an 8-year marriage, she would be entitled to 4 years. So you can calculate what that 4 years is worth. Okay? So when you represent a husband, you can buy out that. You can
Like a lump payment?
A lump payment, or you can trade assets. And that's really important, because if you trade it, then you don't have to worry about going back to court on modifications, court time, and lawyers, etc. Okay. So in a long-term marriage, I valued that her support would have been minimal, let's say 10 years at $7,500 a month, which is $90,000 a year, times 10 years is $900,000. Now comes the major issue of tax on that, which Ms. Ebersbacher didn't discuss at all. But
explain to us then what the tax situation was, for lack of a better term, in 2017.
Taxable to the recipient, deductible by the payor, meaning Mr. Sementilli gets to deduct all the spousal support on his tax return should they separate in a divorce. Should they get divorced or just separate?
So it's going to cost him less in net funds.
Correct.
What about the benefit to her financially?
She has to pay tax on all the money on spousal support. but she wasn't making that, which is what we found over the years. And, you know, it's wonderful now, because you see, you know, I have, you know, I represent an executive at Disney who's what happened with President Trump in his first term is they changed the law that had been in existence for 75 years, and now, as we sit here today, the payor, in this case, who would have been Mr. Sementilli, he can't deduct it anymore.
And what about the recipient?
She gets it tax-free, which is much harder to make a deal because there's no taxes involved.
But let's now go back to the year of 2017, which this chart was based on,
Right.
which was the year that Mr. Sementilli was murdered. How would the alimony have affected the figures in this chart?
Well, you can add $1 million to this chart.
On what column?
She didn't have a column for it. There's not one column for it.
Well, is there a divorce column and a death column at the top?
She had a difference of $1.5 million, death greater than divorce.
And if you would have added the amount that you're indicating that Ms. Sementilli would have been entitled to in alimony, how would that have affected that chart?
I would have deducted $1 million from that number before I analyzed all her other assets, which, you know, like the stock options is completely wrong. But But I would have deducted $1 million.
Which would have
Can I explain further why?
Sure.
It's my professional experience that in a long-term marriage of 20 years, that she could have gotten support. Many judges in LA, and all my work, 90% of my work, maybe 95, is in 2 blocks away on Hill in LA County. Ms. Ebersbacher is a forensic accountant, not an attorney, from San Diego.
Well, tell us what your opinion would be based on as opposed to hers.
That an LA County judge easily could give her retention of jurisdiction support, meaning support for life, meaning that she could get it for, they were in their 40s. I mean, she could have gotten it until he retired at 65.
Whatever his age was at death, he would...
Well, support, there are the terminating factors in support are remarriage, death of either spouse, or, quote, further order of court.
All right, so let's take that one at a time. If you are divorced and your alimony is awarded, you talked about $7,500 a month. That would be in place until either Ms. Sementilli remarried or Mr. Sementilli died, correct?
Or she died.
Oh, she died.
Or she died.
What if he died and she was getting alimony?
Terminates.
Okay. And
which is...
Go on.
I'm just trying to move it for you, but...
Help me out. I'm still married.
No, spousal support for his death. It's not on this chart, but in every case that I handle spousal support, a major factor is life insurance on the payor spouse's life for the recipient. So I always would make sure, like in this case, if the Sementillis come to me, I would make sure that Mr. Sementilli had life insurance, either through substantial life insurance, either through employment or a separate policy to protect, it's in the code, security for support. Because upon his untimely demise, he has a heart attack and dies, she gets no more spousal support.
Okay. So you see on this chart, which is in front of you, there is a section for life insurance. Is that correct?
I see it, 24, line 24.
All right. So that's life insurance proceeds, which under the estate the figure is $720,000. You see that?
I see it.
Then you see on the right, there's another figure of 720, and that goes over to the final line of 720,000.
I see it.
Now, if they got divorced, what you're saying is that the life insurance, since alimony would end upon his death, would be protected by the life insurance. Is that correct?
Correct.
And
But I couldn't tell from this, you'd have to look at the footnote, I couldn't tell from this whether that was a separate life insurance policy or this was the policy from his employment that he designated her 40%, 40%.
okay,
But-
let's assume that it's from the employment. That's where he obtained it from. What you're saying is you were informed that it was split 40% for her and then 40% for the children. Is that correct? Or 60% for the children.
60 for, exactly. There were different policies split different ways, but that's basically, she was getting 40%. But this would be a good protection for her security for spousal support if it was already in existence. Because
All right.
I'm sorry to say husbands and wives because I'm an old timer, but I make husbands get life insurance to protect, in the event of their demise, to protect the wife who would lose the spousal support.
All right, so let me try to put that in layman terms.
Okay.
If Ms. Sementilli divorces Mr. Sementilli and gets your figure of $7,500 a month, that could carry on until he was 65 or she remarried, correct?
Absolutely correct.
All right. But if he dies, as he did in this case, he was murdered, then alimony would no longer be paid, obviously.
Absolutely correct.
Okay. So, simply put, he would be worth far more had he lived because he'd be paying alimony than upon his death. Is that correct?
In my professional opinion, there was no question he'd be worth more that he stay alive than he die.
Plus, if he lived and there was a divorce, she not only would get alimony, but upon his death, the life insurance would still apply. Is that correct?
She would get life insurance for security for the, yes, that is correct.
Well, security or not, as long as he continued the life insurance, he'd be paying alimony, and upon his death, that would be, you say that there would have to be security for her, or she'd have to be a beneficiary, correct?
Yeah, if this was just through the employment, I probably would have gotten even more insurance for her to protect her spousal support.
You're bragging.
No, I mean, it's really, I think it's, you're hired to do a job. I mean,
Is there any question in your mind that he, just from a financial point of view, was worth far more alive than dead?
Worth far more alive than, absolutely. First of all, you have to assume he's going to create greater earning power to be alive, and like he's making $280, okay, and he's a young man. I don't know. Only what I've heard here. I don't know how old he was upon his demise, but you have to assume he's going to make more. You have to assume that if I had handled this, the house. Okay.
He was 49 years old.
Okay, 49 years old. So his life expectancy, and he's going to live and make more money. The assets. I mean, you can.
In other words, if he's alive, as long as they're married, she's living the same lifestyle, we would hope, as she was at the time in 2017, correct? Or even greater, you're saying?
Well, the purpose of a family law attorney is also to try to get, in the event of a divorce, where you're now taking a paycheck or paychecks and dividing it in half, to try to keep both spouses in as close to the lifestyle that they have, upon divorce. That's why you can see they sold the house. If you want to get to the house issue,
Well, it looks like it was divided equally. Does that make sense?
Right, but in a divorce, the worst thing you can do is to sell the house. What you try to do, if I represent Ms. Sementilli, I would try to get her to the house and give him other equalizing assets, because the house is going to appreciate. You can imagine what houses in LA County appreciate in 5 or 10 years, and she's got a house to live in. So let's assume the equity was $500,000, the net equity. Okay, if you don't sell the house, if you make a deal, there are no costs of sale. You don't deduct that $100,000 that's on here. There are no broker's costs.
That's the cost that was involved in selling the house, which was sold.
Right, right. You want to avoid that if you can, and try to make a deal between spouses, because then you don't have that. You also then have, if you represent wife in this case, she has a place to live for the next 10, 20 years. You don't know what the mortgage rates are. Maybe they were low, now they're 6, 7%. Maybe they were lower. So there's so many factors that would have been better for her in a divorce than any untimely death for him.
And just to summarize, those factors involve the increase in the value of the home, it involves the alimony, and it involves the life insurance that you would try to maintain to protect her if he had an untimely death, correct?
Correct.
All right. One last item I asked you to look at.
Okay.
And that was the options.
Correct.
Do you see a figure of $935,000 halfway down? That's line 16. You see that?
I do.
Okay. And if you go to your left, do you see the amounts of $795,000 and $140,000? You see that?
Yes, I do.
Okay. And on the far side to the right, there was a figure of $537,000, which Ms. Eversbacher said would be the advantage to Ms. Sementilli for those options upon the death of her husband in 2017. You see that?
I do.
Now, was that based on the value of the options in 2017, or for some reason did Ms. Eversbacher calculate the value of the options in 2024?
Yeah, that figure is 100% wrong. You'd have to look at it, footnote E, but it's my understanding, reading E, that the options were worth $74,000 at the time the time of his 2017, and they became 7 years later. After everything happened, apparently they became an E. She even says the value of the $74,000 was, the value of the $900,000 is in February of 24. So 7 years later, the stock options are now worth $900,000. Now you go back to the analysis of the divorce. What's my job? I handled the CFO of public storage. The only issue in the case was millions of dollars worth of stock options.
So
Okay.
what should have been considered in a death versus divorce analysis, the time of death or 10 or 8 or 7 years later?
Well, the issue there becomes, do the parties, let's assume they separate and they're getting divorced in 2017 or 2018 or 2019, okay? It takes approximately 2 years to get, in my professional opinion, to get a division of property in a divorce case.
But let me ask you this. In death, would not the value of the options at the time of death be the figure that you would consider?
Well, that's a tough question.
Not in a divorce, just if you die.
Well, I don't know. In death, can the estate? I don't know. That's not my area of expertise. But in death, does the estate invoke the options? One thing she didn't deal with, Ebersbacher.
Excuse me. There's an objection, counsel. You know I have a
I'm sorry, Your Honor. I'm just going.
Yeah, I know.
I'm sorry.
Sustained.
I'm sorry.
All right. I'm just talking about the value of the options was what in 2017?
$74,000,
And the value in 2024 was what?
$900,000.
Okay, and we went over this with another witness, Ms. No, I believe. And in your opinion, if you were evaluating the value of the options at the time of death in 2017, would it be what they were worth in 2017?
Oh, absolutely.
What you're saying is if she got divorced, then you're talking about the options as being worth perhaps a lot more because they don't know what they're going to be worth down the road, and you would figure that out to the best of your client's advantage if it was a divorce, correct?
Objection, that's speculation.
Correct, because depending upon who I'm representing in the divorce, it's a major analysis there. Because you don't know in 17 or 18, do they divide the options? Does one party buy the other's interest in the option? Like, he could write her a check for $37,000 and he could own all the options, okay? They could divide the options if the company allows them to divide them. In a divorce, which is my expertise, you have the issue of when is the option exercisable, when does it vest? Like Ms. Ebersbacher on line 16 divided the options into, I assume, she didn't testify to this, well, maybe she did. CP is community property, SP is separate property. I have no idea how she came to that characterization of the options, because if it's separate property in a divorce, Mr. Sementilli would not have to divide that with his wife.
But if the options were obtained while they were married, wouldn't it normally be community property?
It would.
Okay. So, again, without getting too complicated, all this in the long run is dependent on whether the options go up or down in a divorce case, but in death, there's a specific amount it's worth on the time of death. Is that correct?
Correct, because some options, they turn into, they go underwater. They're not,
If the stock went down.
stock went down.
Finally, was there any indication there or consideration of child support for the child who was under the age of 18, and I think she was already 16 and the other one 18, but at least for those 2 years, would he have been required to pay child support?
He would have, and it would have depended upon, the amount would have depended upon the amount of his custodial time. Like a lot of dads have 50% time of the child, which would reduce child support. But child support's in LA County not like spousal support. Child support's very easy to obtain. It's we had up to just recently a computer program called the Disomaster, where you plug in income and it gives you child support.
But are we talking about a small amount, since in 2 years the minor child would be 18?
Correct.
And at that point, there would no longer be child support as a matter of law. Is that
Unless the child's a full-time high school student, at which case child support goes to 19.
All right. So in summary then, if I asked you, if you were preparing this chart and determining whether or not, for the simple question, which no one should have to face, obviously, what was the worth of Mr. Sementilli in death versus divorce, what would your answer be?
In my opinion, it would have been beneficial for her that he live, and she go through a divorce.
For the reasons you stated.
For the reason I stated, that the options would have been $74,000, not $900. The house.
Well, you've
Talked about the house, talked about spousal.
Okay, for the reasons you've stated,
Yeah.
and the main reason still remains the alimony, which was not even calculated. Is that
Can I
correct?
say one more thing?
Sure. Why not?
When I sat,
Object to that.
Yes, that's, I don't know how they do things in family law, but the evidence goes, sir. Here we have to follow it, sustained.
Is there another factor that you wanted to cite to the issue of death versus divorce?
Yes, well, Miss Ebersbacher, I took a note when I was here on February 10th, and she said that she thought that spousal support would be for a period of 5 years. To me, that would be malpractice.
So you're saying it would be how long?
Well, she included temporary, which is the time of separation, to time of divorce, which in LA County takes approximately 2 years. And then she added on 3 years. Three years in a 21-year marriage is completely unacceptable.
What is acceptable?
A minimum of 10 years. They're married 21 years. It's a lengthy marriage. So,
And could be greater than 10 years.
it could be greater than 10, but to me well, she's not a lawyer.
Well, that's
so-
a major factor on this chart.
Well, major factor to me, and the fact that she told the court and testified to 5 years, temporary and permanent, was, I would never accept any of that in my 40, 70.
Objection, non-responsive.
Sustain.
Thank you.
Okay.
Stricken. We're going to take I know you don't want to take a break. I need to get my staff has to go to the bathroom. So we're going to take about 10 minutes. Is that okay with you? The admin supply. See you back here in 10 minutes.
Tremendously, in your opinion, inflated amount for the value of death versus divorce. Did you have a figure in mind or a range?
Well, I just would have deducted from the $1.5 million that she had death benefit greater than divorce. I would have deducted the $1 million for spousal, and I would have deducted $800,000 for the stock options, which would have been $74,000 at separation, not $900,000 in 2024.
So what would you have come up with approximately as the difference between the value of death versus divorce? If those were the two choices in 2017.
Yeah, I don't have a number for you, but all I can do is tell you my professional opinion is that she would have been much better that if she had to go through a divorce than his untimely death, financially.
Thank you. Thank you, Your Honor.
Thank you. Good afternoon.
Good afternoon,
Mr.
counsel.
Malatesta. So what are the options then if divorce isn't an option? And let's say that you come from a big Italian family where divorce isn't an option, then what?
You stay together and live unhappily, which a lot of people do, I'm sure.
Or if the spouse dies, you come into a windfall, right?
If the spouse dies, you come into a windfall.
Well, you get 100%.
I'm not an estate lawyer. I can't testify about what would happen on death. So.
Well, you've just testified to a lot of things that would happen on divorce versus death. Isn't that why you're here?
No, everything I testified was related to divorce. That's my expertise.
Okay.
I don't do estate planning. I do divorce.
But weren't you here to testify that it's more money to divorce than death? So you are testifying about the difference between divorce versus death. That's why you're here.
Yes, I was here to analyze this chart that Miss Ebersbacher did.
Okay.
And in my professional opinion, using what she had for death, Miss Sementilli would have been better getting a divorce than any untimely death of her husband.
But you just testified that you're not an expert in death.
I'm accepting her death numbers on this
Okay.
chart, except for the options, which it's wrong.
So are you an expert then to compare divorce benefits versus death benefits?
No. I'm an expert in whether she would have been better financially if she had gotten a divorce from him in 2017, 2018, 2019,
Okay.
than him dying during that time.
Okay, so you just did the divorce side, but you didn't touch the death side.
Correct. The death side, I looked at her numbers, but I couldn't tell you.
I got it.
Okay.
So you were hired then in the middle of trial after we started in February of this year to write a report, come in, and testify in court, correct?
That is correct. February, I wasn't really hired to do a report. I offered to do a summary that maybe you would accept my the report in lieu of testimony so we could shorten the trial, but I made myself available to testify.
So you offered to write a report to shorten the trial?
Well, if you accepted my report, maybe you wouldn't need my testimony here today. That would shorten the trial.
So did you offer to do a report because you're personal friends with Mr. Levine?
No.
Are you personal friends with Mr. Levine?
I'm friends with him. We don't socialize and stuff. I've known him for 30 some years. I've never testified for him in any court of law, and in 47 years, I've only worked with him on 2 cases.
So did you run into him when you were out on the town or somewhere in your town? You ran into him and started talking about this case? Is that how you got retained by your friend of 30 years?
Is that relevant, Your Honor?
Sir, you're not in a position to object. Let me stop it. You're a witness. You're not an attorney here.
Okay.
You're speaking as a witness.
Okay.
So you're trying to object, it's overruled. Answer the question.
Okay, Your Honor. Mr. Levine called me in end of January, beginning of February 25, while I assume your trial was going on, and asked me if I could do an analysis of what a spouse would receive in a divorce case in 2017, 2018.
So you didn't run into him and then strike up this conversation out of the blue?
No, of course not.
All right. So when he called you that, then did he offer to pay you for your services?
He did.
And at that point, is that when, before you wrote a report, that you gave him a $7,500 retainer?
No. He gave me a $7,500. I didn't give him a $7,500.
I'm sorry, yeah.
Yeah. So, yes, he sent that to me within 48 hours of our having a conversation about what my responsibility or work product would be.
Okay, so are you currently practicing or are you retired?
No, I'm a member of the bar. I'm practicing. I was in trial last week in Ventura. I have.
That's fine.
Okay.
Now, when you talked about, you know, the joke about an objection in court here, have you testified as a expert on divorce benefits in a criminal court?
Never in a criminal court. 10 times as a divorce expert in divorce cases.
So that's all civil?
All civil.
And it's all based on the side that you're representing, whether it be the male or the female, right?
And I've been appointed by the court on 2 or 3
Is that a
occasions.
yes?
Can I answer the question, Your Honor?
You can answer the question of the propounded, sir.
So I'm going to object non-responsive. Move to
Sustained.
I'm sorry, could you rephrase the question?
Have you practiced or testified as an attorney, as an expert in a case of divorce and how much money somebody may or may not receive in a criminal court case?
I already answered that. The answer was no. You then asked me.
Objection, non-responsive. Can I ask you again?
In a criminal case, I already answered.
Excuse me, Your Honor, you answered no.
No.
Excuse me, sir. It's overruled. It's overruled.
I've never testified on any divorce-related matters in a criminal case.
So this is the one case where you're doing a favor for your friend of 30 years. This is the first time in your entire career that you're going to come into court and testify for the defense in a criminal case. Is that accurate?
That is totally inaccurate. I'm not doing any favors for Mr. Levine, Ms. Sementilli, or anyone in this courtroom, and that's offensive. I'm testifying
Objection,
because I got
non-responsive.
$7,500 to give an expert opinion.
Move to strike.
Stricken.
You were paid $7,500 as a retainer. Before you provided the report or after you provided the report?
Before.
Okay, and that retainer involved what? What was your understanding that retainer would be for?
I would analyze what the parties' divorce would look like in 2017 and 18. That was one. Two, I would make myself available to come to court to listen to your expert, if you had an expert, and critique that expert's opinion. And three, I would make myself available to testify.
Okay, and then you testified that at the conclusion of those 3 points that you just made, you feel as though your $7,500 will, for lack of better words, be used up. You're going to have at least billed $7,500 for those services, right?
I estimate that will cover all of my time in this case.
Do you estimate it's going to go over that?
I really don't.
Okay. And that's for writing a report, coming to court and listening to testimony, and then coming again today to testify. Is that right?
That is correct.
All right. Now, you have not ever had a conversation with the defendant in this case. Is that correct?
Never.
And prior to this, you never knew the Sementillis or the state of their marriage?
Never.
So if there were to be a divorce, it's fair to say you have no idea what the terms would be if they even agreed on certain aspects of a divorce, right?
That is correct.
Because sometimes people get divorced and it's amicable and they work it all out and they never hire someone like you, an attorney, correct?
That is correct.
So you're just estimating that this would be a hostile divorce and the best benefit for the client, which would be in this case, the defendant.
Wrong. Not correct.
Okay, what's not correct about that?
Even if it was a mediation, which I'm doing now, which is not hostile, the parties negotiate terms. The terms they would negotiate would be division of assets, in this case spousal support, child support, attorney's fees, which is a major issue, because if they had gotten divorced, in my opinion, there would have been major attorney's fees involved. So I'm doing mediation now, and I'm enjoying it, but I'm mediating major cases.
Objection, non-responsive to the last part, move to strike.
Sure.
So your conversations with Mr. Levine, you knew about the defendant in this case. How old was she when her husband died?
I believe I was told in her 40s.
Okay, 44, does that sound right?
That sounds right.
And then you weren't sure how old Fabio was, but if I told you 49, that sounds right?
That sounds right from what I heard today, correct.
And then you estimated that if there was a divorce, and this would be under the assumption that it's a contested divorce, correct?
No.
Well,
it could be mediated, which is not really contested. Contested, you mean like litigation in court, I'm in trial, or do you mean mediation? There's many different, avenues of divorce, but.
Exactly, there's a lot of different avenues of divorce, right?
Right, and if I was a mediator.
So, objection, no response, no question pending.
Very good.
Are you allowed to answer the question?
He's volunteering, counsel. That's not responsive.
So there's a lot of avenues for divorce. You can't say exactly what would have happened had the defendant divorced her husband, who you don't even know. Right?
And that's hard to answer. I can.
Is it?
No, in a 21-year marriage, you get so many years of support.
Okay,
period.
sir, who told you it was a 21-year marriage?
Miss Ebersbacher.
Okay, so what if I told you that that's incorrect? Did you speak directly to Miss Ebersbacher?
No, that's what she testified to.
Okay, so it's a 19-year marriage. Does that change anything?
No, nothing.
All right. Now, based on that, again, all these different avenues, not knowing Mr. Sementilli, not knowing the defendant, she could have gotten substantially more than what you've estimated, right? He could have given her a lot more.
I mean, that's correct.
Right.
A lot less, a lot more.
He could have also said, nope, you're having an affair with this guy. I found out about it. I'm not agreeing to anything, and that divorce could have drug on for 10 years, right?
I see a lot of affairs, and I've never had a case
I didn't ask that.
drag on anywhere near 10 years. You used 10 years.
Okay, could have drug on for years, right?
5 years? Yes.
All right? So that doesn't mean it would have been resolved that day. Now, you also testified that, in your opinion,
Is that a question?
It sounds like testimony.
you also testified that she would receive, in your opinion, $90,000 a year, and that's if you're using a formula with the family code, I assume.
I used Miss Ebersbacher's numbers of $280,000 average annual income for Mr. Sementilli. I used $20,000 for Miss Sementilli, and I used all of the factors under Family Code 4320.
Okay, what about the fact that the defendant is 44 years old? In your experience of all these years since 1985 practicing, do the courts say, you know what, you're 44, you were a prior teacher or professor or whatever version of teaching, and you know what, just kick back. You don't have to work. You don't have to get a job. You're going to get $90,000 a year. Is that how it really works?
She would get $90,000 a year, period. But what you're getting to, Miss Ebersbacher brought up, which is interesting. You want to talk about it? We should. Which is the Gavron warning. The Gavron warning in California states that if you're able to work, you should try to work. Doesn't mean you're going to be self-supporting. Just means if you're able to work, you should. Now, if she made 30 or 40 or 50, if she made $100,000, it would change the equation. She would get less support.
Right.
But maybe Mr. Sementilli, if the case dragged on for 5 years, is now making $400,000 or $500,000. It would not. He'd pay more. He wouldn't pay less, even if she was making $100,000. So.
Okay. Again, let me ask you this: the Gavron warning. I understand what you're testifying to, but again, she's 44. You're not saying that a woman who's 44 who has a teaching background couldn't go out and get a job, are you?
I'm saying that the courts require that people look for jobs if they're able to work.
And a 44-year-old healthy woman who has a prior career, who gave up that career to move to another country with her teen daughters, that would be somebody that would be able to work again.
You'd have to analyze then, does she have a teaching credential in California?
Okay.
If she doesn't, then she has to go to school.
How do you know that?
You can't teach without a teaching credential.
How do you know she doesn't?
I don't.
Okay.
I want you to tell me.
I'm not telling you anything, sir. That's not how this works. I'm asking you questions, and then I'm asking you to answer. So, again, my question is, you're not saying that the courts would look at a 44-year-old woman who has a history of teaching in California, let me put that in there, and say, you know what? You can divorce this man who makes $280,000 a year, and we're going to give you $90,000 a year for the rest of your life, and you don't have to do anything. Does that sound reasonable?
I'm telling you that that's what would happen in the beginning of a divorce, and they would probably, which they do, bring her back in 2 or 3 years to see if she's made efforts to better herself, to get a job, etc. And support is always modifiable, which means you come back and you see maybe he's making more.
Okay, but you didn't say any of that on direct exam. You said she would. Did you say any of that, what you just testified to on direct exam in front of this courtroom?
I could talk about spousal support for hours.
I'm sure you could. I'm sure. I don't think anyone doubts that.
My expertise. But
Right.
If you ask me, I'll answer the question. I was not
I'm
asked.
really trying. So
Okay.
the question is, again, did you testify to any of that about the fact that the defendant would come back in 2 or 3 years to revisit to see any efforts that she's made to get a job, which is what the court is looking for?
I was not asked that. The court's
Objection non-responsive.
Well, I don't know. I'll take your objection under submission. Finish your answer, sir.
the courts don't necessarily, they bring you back to make to in some cases, you know, they have so many cases, but they'll bring you back to see if you're with Gavron in a lengthy marriage, because he would be ordered to pay that $7,500 for a long time.
Same objection.
I'm getting to her answer, which is they would want to make sure that she's making efforts to better herself with, like, I'm assuming she has a teaching credential. They would expect her to be looking for jobs, looking for work, assuming there's no other health-related factors or anything like that. They would want her to be bettering herself. That's what Gavron means.
And my question was, did you testify to that on direct exam? Yes or no?
I wasn't asked about that. I can't testify.
Objection non-responsive.
As responsive, Your Honor.
I'll allow it for me.
Okay. You did not testify to that on direct exam. Is that correct?
I was not asked that question.
Okay, did you go over that with your defense team, Mr. Levine, your friend of 30 years?
Your Honor, that's
Argumentative.
Yeah, may I say something?
You may say nothing, sir.
Did you discuss that with Mr. Levine? The fact that the courts would require her to try to get a job.
We discussed what Gavron means. Your statement that the courts would require her to get a job is false. The courts would not require her to get a job. The courts would require her to look for a job and to do as much as she could to try to better herself. If she's able, health-wise, education-wise. There's so many factors. Do the minor children, do the adult children, are there any disabilities in the family? Are there any other?
Did you discuss what you're testifying right now with Mr. Levine and his team?
No, I did not.
Wouldn't that be something that should be considered now that we're talking about it in court and you're here to testify the benefit of divorce, which is your expertise?
Nothing you've asked me would change my professional opinion of what she would get, which would be the $7,500 a month for a minimum of 10 years and maybe for life.
All right, we're going to move on. Now, none of this matters, though. None of this matters if she gets married, right?
Yeah, remarriage terminates spousal support.
Okay, did Mr. Levine talk to you that the defendant was having an affair and was already utilizing the last name of her boyfriend?
I've represented hundreds of people in affairs.
Objection non-responsive.
Sustained.
Affairs do not.
Objection non-responsive.
Sustained. Listen to the question, sir.
Okay. I'm sorry, could you repeat it?
Did Mr. Levine and you discuss that the defendant had a boyfriend and was already wanting to use his last name as her last name, indicating that she's going to get married to him? It's a yes or no. Did you discuss that?
No.
Okay. All right. Now, we go into life insurance. You said your practice is that with life insurance, you would write it into any divorce agreement. Is that right?
I write it in 99% of my divorce agreements to protect the recipient spouse, be it male or female, because death terminates spousal support. And in cases where there's big money, you want to make sure that somebody gets money upon the untimely death of the payor spouse.
Would big money be $720,000? Is that considered big money?
Yeah, to me it is.
Okay, so if the spouse dies and the defendant gets $720,000 without any clause in any contract or agreement, there's no dispute to that, right? You just get it.
I don't know from your chart where that money came from. It didn't state whether that was an employment benefit, a separate policy.
Well, I didn't reference a chart. I asked you a question.
Well, that 720 came off the chart.
Objection non-responsive.
Sustain.
Move to
So
strike.
Stricken.
So, somebody dies. There's a policy for 100, let's say, do a hypothetical. Somebody dies. There's a policy for $720,000, their share. They die. The spouse dies. The other person just gets it, right?
Is that security for spousal support? Who's the beneficiary? What are you asking me? I don't. Are you asking me, does the beneficiary of the policy get the money upon death? The answer is yes.
Thank you.
But you have.
Okay.
Forget it.
And then the stock options, the last topic. You're not an expert in stock options, I take it, right?
No, but I've handled millions of dollars worth of stock options. One case was.
Objection non-responsive.
Everything after millions of dollars of stock options is non-responsive.
Stock options then. You're aware that there was stock options involved in this, and you put that into your testimony as an analysis of a why divorce would be better than death is based on one of the factors was these stock options that you testified to, right?
Yes.
Okay. Did you know when those stock options vested?
I did not.
Okay.
But I believe Ms. Ebersbacher in her chart says that she uses a 3-year period of vesting, which I have no clue how she got that.
All right. Do you know from Procter & Gamble, the company where the victim, Mr. Sementilli, worked, do you have intimate knowledge of when those stock options vested?
I do not.
Okay. So, you do understand that they vest upon death, right?
No, I don't know that.
You don't know any of that.
No.
So
I'd
then
have,
how are
I'd
you
have to
test-
review the options.
Then how are you testifying to her receiving stock option money as part of her divorce benefit?
I accepted Ms. Ebersbacher's number of $74,000 that they were valued in 2017.
Okay. And then based on that, so you didn't do anything further with the stock options?
I also assumed that they were community property.
So
Maybe they were, maybe they weren't, but I assumed they were.
if your assumption's right, she would get half of that.
That's correct.
All right. Do you know the expiration dates
I
on
do.
those? Can I finish my
I'm
sentence?
sorry, I apologize.
Do you know the expiration date on those stock options?
I do not.
Okay. So, you're not an expert in stock options,
Ask and answer.
No rule.
I
right?
consider myself almost an expert. Yes, in divorce cases,
So
yes.
that's, you consider yourself almost an expert in stock options?
I would delete the word almost and say an expert in stock options in divorce cases.
All right. But in this case, you didn't look at the stock options to know any of the details of them. You just looked at a chart by another witness.
Totally correct.
All right. But as an expert, wouldn't you want to look at those stock options, when they vest, when they expire, to intelligently testify as to the benefit to the surviving spouse?
In my report, I stated on page 2 of my report, my stock option analysis would have included, in addition to figuring out the 74,000 number, but I specifically wrote, answers to the following questions, which were not discussed by Ms. Ebersbacher, such as, when were the options granted? When do they vest? When may they be exercised? How was the community-separate characterization amounts arrived at? And finally, what happens if Mr. Sementilli left his employment at Procter & Gamble before options vested? These were a myriad of questions that I would have considered in a divorce case.
Right.
Not really my job in this case, but
Okay.
I wanted you, if Mr. Levine shares this report with you, I wanted you to know that these are questions that I would have considered in a divorce.
So those are very valid questions, and you wrote them out. 1, 2, 3, 4. Did you go to the defense team who hired you to testify about this topic and ask those questions?
I gave the report to Mr. Levine, and I didn't feel like there was anything more to do other than to say these were issues that needed to be raised if you wanted it to go further.
So is the answer no, you did not ask to discuss those questions with Mr. Levine?
No, I gave him the questions. We didn't discuss them any further than this. Okay.
Right.
Okay?
Wouldn't you want to know the answers and ask him for discovery on those questions that you wrote out? Wouldn't that be important to your discovery to discuss that with the defense attorney so you don't come in here and say, well, I wanted to know this. I wrote out that I wanted to know it, but I didn't ask him and we didn't talk about it.
Your Honor, that was not his assignment.
I'm sorry, sir. That's not a valid objection either.
Well,
Thank you.
since fact's not an error.
It's overruled.
That would have entailed spending another $25,000 to $50,000 in legal fees
For you.
for me to get the information, to analyze all the information. I felt like I could answer all the questions in a divorce case in 17, 18, or 19 without going further, because we knew that you had given us a number of what they were worth in 17, $74,000. That's what Ms. Ebersbacher gave us. So we can use that number. Now, and we know what they're worth in 2024, because that's what they received, the $900,000. Anything in between, I mean, I didn't really feel it was my job to keep going further.
Okay. So it was
I wasn't told not to go further. It was.
all right. So you're just asked to look at a report written by somebody else and talk about stock options, but you don't know when they vest and when they expire, because that would be important to know.
That's correct.
All right. So you don't know with stock options. Again, you can't say what the defendant would have gotten with stock options. You don't know. You can't say when they vested. You can't say when she would exercise them. And certainly, you can't say that she would exercise them all at the same time, at different times. You don't even know when they expire. So you can't factor a number in and say it would be much cheaper, because remember, she'd get half of them, right?
She'd only get half up to the date of separation.
Okay. And if her husband dies, she gets them all.
I don't know that.
Well, where do you think the stock options go?
Objection, that's not a question.
Well, it is a question. It's speculation.
Speculation.
Sustain on that ground.
Okay. And in fact, they were exercised. You know that, right? In 2024.
I know from
From the
Ms.
chart.
Ebersbacher's report that
Right.
apparently the parties received $900,000
Right.
from exercising stock options, but I don't know, as I testified on direct, I don't know the breakdown of the community separate. I don't know where that came from.
Okay.
That would,
So, but you do know that they were exercised in 2024, and it's $935,000.
well, Procter & Gamble stock, I assume, went up from 2017 to 2024, like the rest of the market, like Apple and Amazon and Microsoft.
And that value, because they were exercised, Fabio's dead, so there's now her husband, if you don't know the name, there's $935,000 then that has to go to someone, right?
It goes, yeah, it has to go to the state, I assume. It has
Okay.
to, it's gone somewhere,
All
right?
right.
Children,
I'm sorry, what'd you say?
children, I don't know. They have he had 3 children, that's my
You
understanding.
don't know any of that. You don't know any of the details of any of the percentages of any of this case then, right?
I know the percentages on, I believe, the life insurance. I have a document that Ms. Ebersbacher gave us
That
with
document again, yes.
the 40, 30, 20.
Can you answer the question without commentary?
Yeah,
Okay.
improper.
All right.
Can you
Good.
answer the question?
He's answering the question.
Yeah, there's a page with I believe it's life insurance. It shows 40% to her and
Okay.
20% children, something. I have that page in front of me.
All right. So just to be clear then, if her husband dies, she gets 100% of everything, right?
Again,
I'm sorry.
I'm not an estate
It's
lawyer.
unclear. 100% of what?
Yeah, 100% of what?
If,
I'm sorry, Your Honor. I don't testify.
I understand.
right.
You know the rules of court, yes.
Yes, sir. Yes, sir.
And if she divorces him, then 50% is the most that she'll get typically in a divorce of all these different things you've talked about, right?
Yes, unless they did a trade, like I told you before. They could
Okay.
trade the house for options, maybe. They could trade pensions for options. They could trade his car. He had a Porsche or something like that. They could trade a Porsche.
All right.
For
There's a lot of maybes.
a lot of maybes. But not a maybe on spousal support.
50%. Well, spousal support's less, but 50% for the most part, right? And versus 100%. Is 50% less than 100?
Sorry, 50% and 100% of what, Your Honor?
I don't know if they, and that's the objection, that's all.
In general, you're a numbers guy, you're an attorney. Is 50% less than 100%?
You talking about mathematics?
Yeah.
I'll stipulate.
You accept that stipulation?
No.
All right.
You can answer, you can look, I know you're looking at the judge, but he's,
You want me to answer that? Yes.
okay, great.
In this
Thank you.
century, 50% is less than 100%.
Strike the last part.
Stricken. Any redirect?
Oh, yes, Your Honor. Let me put this chart up here. Do you know how this chart came into this trial?
It was my understanding, hearing the testimony of Miss Ebersbacher, that she prepared this.
Yes, yes.
She spent approximately $20,000.
You understand that the prosecution put on a witness to prepared this chart, which came to conclusions that you have said did not include alimony and other factors, correct?
Correct.
And is it fair to say that I asked you to look at the chart and to analyze it if it was accurate or not?
Correct.
I did not hire you to do a complete financial analysis of their marriage, correct?
Correct.
And by the way, whether he had an affair or not, or she had an affair or not, this is a no-fault state, is that correct?
Totally irrelevant in
Whether it's
a
an
divorce case.
Right. So in other words, whether she was having an affair or not, the amount of alimony would remain the same as it would whether they were not having an affair. She was not having an affair,
Totally
correct?
correct.
All right. So the analysis that you had was based on the chart that was presented to you during the testimony of Ms. Ebersbacher, correct?
Totally correct.
Now-
Which I heard in person.
Right. Now, I retained you to analyze that chart, and the retainer was $7,500, correct?
That's correct.
If I had hired you to do a complete financial analysis of the finances of the Sementilli family, it would have been a lot more money, correct?
Minimum would have been $35,000 and $50,000 retainer.
But-
because of mostly the stock option issue.
Okay.
Probably.
And the reason the stock options are so high is because they were not exercised for 7-8 years, correct?
Correct.
Do you know why they were not exercised for 7 or 8 years?
I do not know.
Do you know whether or not the estate actually got a letter from Procter & Gamble telling them if they didn't exercise them, they were going to lose them all?
I only knew that from you telling me that recently.
All right. And do you know if Ms. Sementilli even knew about the stock options that ended up being exercised in 2024?
I have no knowledge of what she knew, period.
Now, do you know?
I've never spoken with her.
Do you know that the death of Fabio Sementilli was in January of 2017? Do you know that?
I knew it was in 2017. That's all I knew.
Do you know whether or not she was not in custody for 4 months after his death. Do you know that?
I did not know that.
Okay. So during those 4 months, she could have exercised any or all of the options, correct?
I don't know that. I don't
Okay.
know if she was allowed to exercise them.
Do you know if she exercised all of the options?
I do not know that.
And do you understand that the reason they're worth $900,000 is because the passage is 7 years, correct?
That's correct. I assume.
Do you think it was worth it for her to be in prison for 7 years in order for the options to go up?
Of course.
Objection, argument.
That's an improper question.
Do you know whether or not during those 7 years she made any attempt to exercise those options?
I do not.
Do you know if she even knew about those options?
I do not.
So do you know whether the prosecution hired an expert to analyze the entire financial analysis of the Sementillis?
The only thing I know is that Miss my knowledge is limited to Miss Ebersbacher's testimony and report.
So this report was prepared by Ms. Ebersbacher for the prosecution at no cost, right?
No, Miss Ebersbacher was testified she was paid
Right.
approximately $18,000 to $20,000.
Yes, by the taxpayers like you and I, right?
Correct.
Argument.
Correct.
Counsel, take a deep breath. You're getting argumentative, and I'm going to have to break right now.
I'm done. I'm done. If the court,
Go ahead.
all right. Is your testimony based then on the chart prepared by the prosecution and the testimony that you sat here and heard from Ms. Ebersbacher? Is that correct?
And my 47 years of experience as a divorce attorney.
And have you done your best to analyze that chart and then conclude whether or not it was accurate or not accurate?
I have.
And finally, the best option would have been for them to stay married, and then none of this would come into play, right? If he didn't die, the best option would have been to stay married and not get divorced, right?
That would have been a good option.
Okay.
You don't want anybody, you know.
But he was murdered, obviously, and that's
Yeah.
what we're here to decide.
Right.
But the best option would have been to stay married financially, because then you could get divorced later on, right?
Oh, without a doubt, that was the
And
best
finally,
option. Without a doubt.
on Gavron, you said it would be adjusted every 3 years based on the money that Ms. Sementilli might be earning, correct?
No, I did not say that. I said that it's common in LA County that a judge will bring a case back in 3 years
Okay.
to review efforts made by a spouse.
Okay, let me just, because we're running out of time.
I'm sorry.
Would it also consider how much increase in salary Mr. Sementilli had in those 3 years?
Absolutely, yes.
So if he was making $300,000, $400,000, or $500,000 over the 20 years you're talking about, then alimony would go up. Is that
Yeah,
correct?
Absolutely.
Thank you. I have none.
Will there be any more? No. Thank you, sir. You're excused. We're going to take our adjournment at this time until tomorrow at 9 o'clock. The admonition applies. You're not to discuss this case among yourselves with anyone else or to form express any opinion until the cause is finally submitted to you. Have a good evening. See you tomorrow at 9.